Are you looking to expand your aesthetic practice and attract high-quality new patients? Discover the power of digital marketing in growing your practice with a personalized strategy session. Join Ryan Davies, Equa's Marketing Director, for an exclusive 90-minute meeting. Ryan and his team will invest hours prior to your session, crafting a customized marketing plan tailored specifically for your practice. This invaluable opportunity comes at no cost to you, with no commitments attached. Schedule your meeting with Ryan today and take the first step towards transforming your practice with the potential of digital marketing.
Get ready for an extraordinary opportunity. You're invited to join our exclusive monthly webinar, brought to you by the Aesthetic Institute and the Business of Aesthetics community. Don't let this chance slip through your fingers. Secure your spot now for a game-changing experience. Explore the details on our homepage at www.businessaesthetics.org and get set to transform your strategies.
You are listening to another episode of the Business of Aesthetic podcast series, brought to you by our gold sponsors MRP and Equa Marketing. We also want to thank our silver sponsors, Pro, Knox and Lenja Law. If you would like to network and share your experience with our podcast guests and other aesthetic industry professionals, join our Facebook or LinkedIn communities by searching for Business of Aesthetics. Get ready for an insightful conversation as we connect with a true luminary in the world of aesthetics. Our host today is none other than Jeffrey Richmond, an award-winning expert in the aesthetic industry who specializes in cutting-edge research, light-based and laser dermatological therapies, and radiofrequency technologies for dermatology and cosmetic surgery practices. Over to you, Jeff.
Good afternoon and welcome to the Business of Aesthetics podcast show. We're thrilled again today to have Sara Shikhman from Lenja Law. Sara has been an all-knowing legal aid to this Business of Aesthetics community. We're blessed to have her again, and today's topic is 2024 legal things that we need to know. In 2024 changes, and Sara's going to go through this with us, but 2024 legal changes, things our practices need to know. Sara, thank you so much for joining us again.
Thanks, Jeff. I'm excited to be here and happy to share the knowledge and learn together and help everyone prepare for 2024.
I think it's, we spend all this time and work with our lawyers and accountants, and we put everything together, and it all feels like it's together, and then a new year comes and there's rule changes in a lot of cases, and we don't think about it. So today we're going to go over some of those rule changes. Well, let's jump right in. So the first thing I've heard on the news, I'm sure everyone's heard on the news, unless you're one of those, 15 states in the South that remain at the 1970 minimum wage. For most of the country, the minimum wage has been raised again and pretty significantly. Can you talk about how that may affect us in the medical spa world, and also other changes I know around minimum wage? They probably didn't just change minimum wage.
Yeah, definitely. There have been a lot of minimum wage changes this year, and the minimum wage is very different from state to state. And the minimum wage also depends on what type of workers you have and what tasks you're assigning to them. So it's really important to check with your attorney to see, okay, what type of workers you have and how much you're supposed to pay them, and then what constitutes a full-time worker in your state, because that's also being changed in some states. So just keeping in mind that sometimes people who are considered day workers or people who are working with their hands or doing manual labor, which actually in some states an esthetician can be qualified as that. There are some states that say that those people need to be paid an even higher wage. So you just have to check to make sure that you're paying people the appropriate amount. And the other thing to watch out with that is no matter what, you have to make sure people are making a minimum wage. So you can't have people show up to work and like wait for clients and then not pay them at least minimum wage when they're sitting there and waiting to have patients. So that's something to watch out for. And also a lot of times when somebody leaves, we want to charge them for things like their uniform or the products they use or something that we think they stole from the practice. Whenever you're trying to do that, you also still have to make sure you're at least paying them their minimum wage. So that's really important.
Along with that, if my employee is not, I guess if I put that employee under payroll, then I'm dictating hours. But are there cases where estheticians can be 1099 employees and they're earning maybe a percentage of what they're bringing in, or they're not getting paid on those hours that they're there because they're an independent contractor using our space? Or what are your thoughts on that?
Yeah, there are situations where you could have people be independent contractors, but the agreements with those people have to be very carefully worded. And there are some states that really prohibit certain types of jobs to be independent contractors. So it really depends on your state and how you word your agreement with people. And it becomes problematic. Sometimes people say things like my 1099 employee. Well, they're either a 1099 contractor or they're an employee. They're never a 1099 employee. And just by saying that about them, sometimes we get ourselves into trouble. So I have to be super careful with that and having contracts. And yeah, if somebody's just a straight contractor, you could have a situation where they're only getting paid for when they have clients, but the contract has to be very carefully worded so that they can't later make a claim that actually they were an employee. Because the determination of who's a contractor and who's an employee is not just what you say in the contract, but it's what actually happened and whether that meets the test that your state has for employee versus contractor.
Great. And lastly, on this subject, I with an employee policy and procedures manual, there may be the family leave changes and things that happen. It seems like a lot of that stuff happen annually. Do I need to update my employee manual annually as well?
Yeah, definitely. And that's a really good point. You definitely should look at your employee handbook every year, or even more often, because these changes are happening all the time. There are a lot of changes that happened with FMLA for this year, and a lot of state-specific changes too. So the FMLA is federal, and that's one part, but there are also going to be changes that are state-specific, and they really vary a lot state to state. And you can get into a lot of trouble if you don't comply exactly with how many sick leave hours you're supposed to do, how you're supposed to conduct breaks, who's entitled for paid leave. So yeah, really important to check with your state and your attorney on what FMLA rules apply to you. And also they're very dependent on the size of the workforce you have. So a lot of states have these different graduated rules. So maybe last year you had 3 people, but this year, once you have 5 people, you have to follow a different set of rules. So always good to do this annual checkup at the start of the year.
So rolling along with annual checkups, the every year it seems like within scope of practice, there's some amount of changes that there's rulings or legislation that's happened. And I'm not sure if that's national or state by state, but how do I kind of keep up with that? And what do I need to know about it?
Yeah, so that one is hard to keep up with on your own for everybody. So it's not like the state necessarily sends people an email saying, hey, guess what? We have a new change where RNs can no longer do this type of treatment, or we're clarifying the scope of practice for something else. It's something where we have to reach out to our attorneys and ask them, are there any changes pertaining to my state and my case? So for example, this year in particular, a lot of states have come out and said, IV hydration is a medical procedure, and someone before getting IV hydration has to have a good faith exam. So before, where it was a little bit of a gray area, now it's really been clarified that this is what has to happen. And some states have come out saying things like a medical assistant can't administer things like semaglutide, for example. So you just have to check your particular scope of practice updates with each board that your practice is subject to. So if you have nurses, estheticians, a medical director, you'd be checking with the nursing board, with the cosmetology board, and with the medical board. But even if you emailed them, and we have some clients in this situation, let's say you email the board and they didn't write back to you, or you called them and you couldn't speak to somebody, the burden is still on you to make sure you know the laws. So even if it was hard for you to figure it out, or even if every single practice in your state that you know of doesn't follow it, the boards don't really care. The boards want to make sure that you are following the law, even if they didn't proactively tell you about it.
With injectables, or are there certain areas that I'm thinking about estheticians can still inject in a few states, whether that stuff gets changed, or estheticians as well? I mean, do they need to look at what their own boards are saying, or do they follow the physician's rules?
Great question. The estheticians need to check the physician's rules if they're performing things by delegation, and that's kind of one scope of practice for them. And the other is they have to check with their own boards if they're functioning as an esthetician. So estheticians have almost like a double duty to check these two places. And the esthetician scope of practice is changing a lot as well, especially when it comes to microneedling. A lot of boards are coming out and saying estheticians cannot microneedle, or some boards are saying estheticians can microneedle if they do X and Y courses and have certifications. So microneedling has been really a hot topic with esthetician scope of practice.
I want to switch gears a little bit. You sent out a message a couple, maybe two weeks ago, and so I know it was important to you and sharing with the community. And I know at our practice we received something from our EHR company talking about text messaging and needing permission. And I saw something around $1,500 fine per infraction, and I think of how we send out 1,000 text messages at a time sometimes, and thought, whoa, this is we need to talk to Sara about this one.
Yeah, that one can get very expensive. Yeah, so to send people text messages, unlike emails, there are these really strict laws that say that you need to have their affirmative permission, and the permission has to be conspicuous in how you got it. So you can't bury it as part of some other long agreement. It has to have an agreement where they accepted you text messaging them. And if you don't do that, for each person that you did it to, the potential fine is about $1,500. So the way to easily solve that is to have an agreement as part of your intake form that where patients consent to not just text message appointment reminders, but text message marketing from your practice. And I know it's very tempting for people to like buy email lists and text message lists and all that stuff, but you can get into a lot of trouble doing that. Not just your phone provider or email provider closing down your account, but also there are these law firms that really specialize in finding companies who do this. And then you would get a letter from them saying, okay, John Doe received a text message from you. He didn't subscribe. He's like 1,000 other people at your practice, so you owe us, $100,000. So really important to have this agreement for text message marketing in particular, and making sure that it's a conspicuous agreement and not buried in another agreement.
And I would add, Sara, just as a marketing someone, I guess, who thinks of myself as a marketing expert, or someone that's done marketing for decades and spent lots of money, it's intrusive if you haven't been invited. It's annoying and it's intrusive. So I don't think those people that are tempted to buy those lists, your return on that, your open rate, your return is going to be really, really small. So especially now compared to this risk. So were these laws like formalized at the end of last year or something? Why are they just now really coming into play?
Another great question. These laws have not been formalized just last year. They've been on the books for a long time. But what changed in the last year is a lot of law firms have found that companies are not complying with these laws. And so the rate of lawsuits for these issues has really gone up, especially in the last year. So I think, I don't know, maybe it's the post-pandemic, people are looking for new ways to make money, I'm not sure. But the enforcement and the lawsuits around these laws have really gone up. And so for 2024, even if you don't have this paperwork from your clients, just start collecting it little by little, one by one, as people book an appointment with you, as they come in, or if you have them sign some documents virtually, just include this consent for text messaging.
Another subject, Ozempic. We keep hearing about it. I think it's going to be hotter for 2024 than it was for 23. More and more people are hearing about it. I still think they're mostly hearing about the brand name. The manufacturer is doing a really good job. We industry people may know semaglutide, a generic form of that, but Ozempic and to a lesser extent maybe Wegovy have a lot of pull. So, but it seems like most medical are still buying or getting this generically, right? Because we're not seeing as many patients that have active diabetes or some of the other criteria for Ozempic. So what are in 2024, how do I market, how do I stay out of trouble and still offer this service to my patients?
It's going to become increasingly challenging to do this because the pharmaceutical companies are getting very upset at all the revenue that they're losing because people are not buying the brand name as much as they're buying the generic from them. So what's happening is the pharmaceutical companies are saying the way that we can come after people is if they are doing false advertising and using their trademarks and in fact are selling other things. So if you are even mentioning the word Ozempic or like Ozempic or anything like that on your website or in your marketing, and you're actually offering the compounded semaglutide, I would say that's a super high risk area and that should stop. So the number one thing there is to make sure in your marketing, you are selling what it is that you're actually selling. Just like there's the same issue with Kybella and PCDC. Allergan is not really coming after people today for this issue because Kybella is not their like blockbuster drug that makes a ton of money. Botox is. But at any moment, even if you're marketing Botox, for example, and instead when people come in, you're selling them Xeomin or Jeuveau or something else, you're doing the same kind of issue that could get you in trouble. So we have to be careful whenever we're marketing something that we're actually selling to people what it is that we're marketing. So that part is really important. And also in our consent, sometimes our law firm gets somebody's consents to review, and it says something like semaglutide is a safe treatment for medical weight loss. You can't really say that anything is really a safe treatment in saying that you are making a guarantee. So your consent has to be super careful, especially with these non-FDA approved uses for things. So make sure that you never say things like Ozempic or semaglutide is FDA approved or semaglutide is safe, because you can't really say that it's safe 100% of the time. And it's not actually FDA approved for these things. The Ozempic is. So really important to be very careful in your advertising and to have your advertising reviewed by a law firm. Although that's not really fun. We hate, saying no to people when they send us their ad and we're like, okay, change this word, change this consent. But it saves a lot of problems with lawsuits going forward. And then the other thing that's happening is now there are law firms who are coming after people for, so it used to be that you could just get in trouble from the pharmaceutical company for this, but now law firms are finding these plaintiffs like John Doe bought semaglutide from your practice, but you told him that it's like Ozempic. And he was confused. And because of this confusion, suffered X and Y damages. And guess what? There are 1,000 people like John Doe. So we're suing you, it's a class action lawsuit now. So to avoid that, you just have to be very careful with the marketing and how things are phrased on your consents, in your websites, and get that reviewed.
Literally send them over to your lawyer and say, can you look at my wording around this?
Yeah, definitely. It's not fun, but it's something that's really necessary, and it's one of those things where like one change, one word could cost you thousands of dollars. So it's really important to make sure that you're saying that, and also even going further, if you're selling something that's compounded versus off the shelf, I think it's a best practice to put the word compounded in your marketing and in your consent so that clients can't say, well, I thought I was getting non-compounded, but you sold me compounded. People are getting more and more picky with all this stuff. And clients are actually reading their consents very carefully sometimes. So it's really important to just make sure that your consent is super accurate. And that's going to be the first thing that a client's lawyer looks and asks for if someone tries to hire them. The lawyer will say, well, what paperwork do you have that you signed? And they'll read the consent and they'll try to find any problem possible in it.
It's wild to think about I see that compared to pretty often, certainly on the shelves when it comes to drugs, right? You get the Safeway brand compares to, but those have passed their patent dates, I'm guessing.
Yes. And also, I think a lot of these companies, right? Like, let's say the maker of Tylenol is not going to go and fight CVS necessarily because CVS is probably one of their biggest customers. And so even if the CVS on the shelf puts Tylenol like on the bottom shelf and on the top shelf buy the CVS brand, acetaminophen or whatever, compared to Tylenol, CVS doesn't have a big incentive to fight them in this case, perhaps. Whereas in what we're talking about, there is this big incentive to fight. And so you always have to think about it that way. Like, is the pharmaceutical company incentivized to fight this? And if they are, they will. And if they're not, they won't. So, yeah.
Great info. Lastly, this is just kind of a bonus for everyone. This may be something that we need to spend more time with, but you and we were speaking off before the podcast about website compliance, and you mentioned that ADA, which kind of surprised me because I think about stairs in front of the building and how do I wheel someone into the office, but you had talked about it with websites, and again in 2024 being something that we need to look at. It's worthwhile to share. Can you just spend a couple of minutes on it?
Yeah, definitely. So in 2024, we're seeing a lot more enforcement in the fact that websites have to be ADA compliant, and specifically medical websites. So the ADA views your website as sort of an extension of your physical office. And while that may be surprising, it also makes sense where customers are supposed to be able to access your website even if they have a disability. And so your website, just like your office, has to be ADA compliant. So you say, okay, well, like how would someone make a website ADA compliant, right? Like, am I going to build a wheelchair ramp to my website, right? Like that is not something you can do, obviously. But there are things that your web company can do and that your marketing company can do to make your website compliant. And there are different services and plugins and different methods of doing this that are worth talking about, maybe in its own separate podcast. But yeah, in 2024, we've seen a lot of lawsuits already about ADA compliance. And it happens like this. You will get a letter from a law firm that'll say something like, on May 5th, 2023, plaintiff John Doe tried to access your website and book an appointment, but because he's blind, he wasn't able to do so. And we're filing a class action lawsuit against you for John Doe and everybody else who wasn't able to do this. And now, we have an offer for you to settle this with us today for $100,000. So these lawsuits are very real when they come to the FDA compliance, the ADA compliance, because people know that you don't want a lawsuit that has to do with a federal issue that could drag on for years and years in a litigation. So really important to discuss this with your website company and make sure that your website is ADA compliant.
Yeah, I can only see the headline, XYZ Medispa denies access to blind man for service or something, right? I mean, it's sad that these law firms are coming after this from a litigious standpoint. In the same token, it keeps us on our toes, making sure that we allow equal access to medicine the way we need to. And I do the better we want this industry to grow, the more often we need to follow the rules of medical clinics and not other industry. So anything that applies to anything in medicine, we need to, I think a lot of times Medispas think of themselves somewhat retail. And until we see ourselves really as these aesthetic specialists, our industry won't grow the same way.
Yeah, definitely. At the end of the day, it's a medical business, no matter what you call it, whether you call it, Sarah's beauty parlor or, Jeff's, whatever. It's really a medical business at the end of the day, and it has to comply with all the medical rules. And the ADA has been really stepping up its definitions too, in terms of what qualifies and what doesn't. And it's really important that as technology will really bridge the gap, and there'll be more and more medicine will actually happen over the internet. There's going to be more and more scrutiny about what is on somebody's website and what isn't. And as people's physical places may get smaller and their websites get more robust, there'll be more and more enforcement on the websites in 2024 and beyond.
It's such a good point, Sarah, and the amount of effort that we put in, we as the business owners put into our website. We used to want it to just have good information. Now we focus a lot on conversion and how many of these actually end up in appointments or communication, and how many of those end up with paying patients. And we really start to track all that stuff in marketing. So it seems to make sense that our these things need to evolve as well.
Yeah, definitely. I think as more and more things move to the internet, that whole experience will get more and more regulated and more and more litigious, because that's where the money is, right? So it's really important these days to really have a world-class website as opposed to just a website, because if you don't, and if it's not legally compliant, you can get into a lot of trouble.
Well, neither Sarah or I are the super nerds on this subject. I think Naren Aruraja with Equa and some of those folks over there, we need to ask them to do something. You mentioned, Sarah, that there's some plugins available and different things to be able to do to your website, but the minutia of that, I think we probably can expand on for another half an hour.
Yeah, definitely. And I think the website people like Naren are the experts at that for sure.
Great to bring it to our attention. If you're smart enough to be one of Lungula's clients already, this type of stuff is being brought to you by their law firm in communication with their patients. I think that's one of the great things about them having so many, like the economy of scale, to go out and find and research and cull this information, and then having enough of a group to share it with that it's worthwhile, because there's so much overlap. Your neighborhood law firm certainly does not have the capacity to go in and research all of this kind of stuff on a day-to-day basis. So if you are using your brother-in-law as your lawyer, that's fine, but you need to go out and look at some of these issues yourself from 2024 to make sure that you're safe in 2024. Sarah, I want to ask you just quickly before we end here, for those people that are just hearing this podcast for the first time or have not had the pleasure of interacting with you on our Facebook group or on LinkedIn or communicated with you directly, will you share how, if I just wanted to do a piece of this, can I reach out to Lengia Law? If I need to do all of it, how do I get in touch with you, and how do I actually take this podcast and make it meaningful for my practice?
Yeah, definitely. So what you can do is just email us at info@lengialaw.com, or someone can go to our website, which is lengialaw.com, and book a free 15-minute Zoom consultation with us. And we'll be able to answer your questions. You can follow us on Instagram at Lengia Law, and just reach out to the Business of Aesthetics community and the Facebook group and the LinkedIn group. We're always trying to answer questions there, and a lot of people are our clients already. So I'm sure if you ask around there, you'll see that somebody will say, you know, I'm a client already and this is our experience. And we work with nearly 1,000 healthcare businesses as of right now. So we certainly have the economies of scale, and we love helping people grow their businesses. That's my passion. Like, when people call me and they say like, oh, I hired a new person, or I opened a new location, or we're doing $1 million in revenue this year, it makes me happy. So I love that part of the business.
Well, that certainly spreads, and it's probably one of the reasons I love so much speaking with you, and I always am thrilled and have you shared information with our community. 2024 legal pitfalls, legal things that are we need to watch out for. Sarah just mentioned 5 different subjects: the minimum wage and FMLA changes, scope of practice changes, text messaging, and our need to have people have signed off on that, not just blanket text mess. Marketing of Ozempic and other name brand when we're offering compounded. And lastly, a little bonus, getting your website ADA compliant. So all terrific things for us to do. I know we all have a lot of work to do in 2024. These are not huge things. When I really break this down, I can, get my web guy going in a day. I can get Sarah or my law firm working. I can talk to my EHR people. I mean, a lot of this stuff from a delegation standpoint, may just take a day or so for you to organize. So don't let it sit. Don't procrastinate. I'm giving you the kick in the butt right now. Get your 2024 started off correctly. Protect yourself. And if you need additional help, lengialaw.com. Sarah, thank you so much for joining us again.
No problem. My pleasure. It's always a good and informative time. And thanks for having me on the podcast.
Thank you to on behalf of the Business of Aesthetics community. If you love this podcast, share it with your friends, give it a like. If you haven't joined our Facebook group or LinkedIn group or Instagram, you can go to the groups. We have pages too, but the groups have questions. They're a little more selective. So go to the groups. On behalf of all of us, have a great week, and thank you for listening.
Are you ready for more? Swing by www.businessofesthetics.org. Resources for a free ebook and a vault of free resources. Elevate your aesthetic savvy. Explore now. Thank you for joining us this week on the Business of Aesthetic podcast series, brought to you by our gold sponsors, MRP and Equa Marketing, and silver sponsors, Lengia Law and ProNox. Would you like to join our growing group of aesthetic industry experts and get featured on the Business of Aesthetics podcast? Or do you know someone who would love to share their strategies for growth in the aesthetic business, providing quality patient care, or their clinical expertise? Head over to www.businessofesthetics.org podcast show and apply to be featured as a guest on the show. Remember to subscribe to this podcast on iTunes, Google Play, Amazon Music, or wherever you listen. If you would like to engage with today's speakers, or any of our past speakers, join our Facebook group or LinkedIn group by searching for Business of Aesthetics. Thank you, and have a great day.